Hello. So today I want us to discuss the law of hire purchase. So the law of hire purchase, in other terms, is the one that is known as the general principle of consumer credit. So that is the law of hire purchase. So or simply the contract of hire purchase. So this is where the buyer pays a deposit, and after paying the deposit you get the item, you pay installment in future, or you pay equal monthly installments. So the contract of hire purchase, we discussed the nature of hire purchase contract. So definition of hire purchase. So this is a contract by which goods are delivered to a person who agrees to make periodical payment by way of hire, with an option of buying the goods after the stated hire installments have been paid. So when we say that the buyer has an option of buying the goods. So it is not a compulsory that the buyer must pay installments. You have an option. You have an option to pay. Whenever you want to continue in the hire purchase contract, you pay monthly installment. But the buyer is always allowed, in case you want to terminate the contract anytime. There is no, it is not mandatory. There's no obligation that the buyer must pay installment. So what we do is that you are given an option to purchase the goods. So the goods may be returned to the owner at any instance before the option is exercised on payment of sum stated in the contract. Until the option is exercised, there is no guarantee to buy the goods. So you are given an option to purchase the goods. So if you want to exercise that option, you continue paying the monthly installment, and what the buyer gets is the possession of the item. You get the possession of the item, but the ownership or the title of the item remain with the seller. So the contract thus contains three parts. The contract contains three parts, and the three parts are contract of bailment. Contract of bailment. Remember the contract of bailment. See, this is where the hirer obtains possession of the goods, yet the goods remain in the ownership of the owner. So you retain possession. Possession, remember, it's not ownership or title. It is the item is on your hands. That is when we say that you possess the item. So option, which entitle the hirer to purchase the goods on hire purchase or hire them. So you have an option which entitles the hirer to purchase the goods or hire them. Number 3 is the contract of sale, which makes the hirer the owner of the goods already in his or her possession. So the contract of sale, which makes the hirer the owner of the goods already in his or her possession. So hire purchase and other installment sales. So hire purchase and other installment sales. Remember, hire purchase, we are saying it's a contract of hiring. It's a contract of hiring where you buy a machine without paying the whole cash price. You only pay a deposit, then later you pay equal monthly installments. So the hire purchase transactions is intended to protect the owner's title to the goods should the hirer, that is the buyer, decide to sell them to a third party who buys in good faith before full installment is paid. It is worth noting that this differs from the sale of goods act, in which if the buyer is in possession of the goods with the consent of the seller, sells them to a third party who buys in good faith, then the property passes to the third party. The property passes to the third party. Remember, property, it simply means the title of the goods. So property here means the title or ownership. So the hire purchase therefore gives two options. The first option is to purchase the goods. So you have an option to purchase the goods, or you have an option to return them. So you may opt to purchase the goods, or you may opt to return the goods. By returning the goods, it means you fail to pay installments. And therefore the buyer will take his goods. So, in the case of Herbie versus Matthew, a case of 1895, the owner of a piano agreed to let it on hire, the hirer to pay rent or monthly installments on terms that the hirer might terminate the hiring by returning the piano to the owner, but remain liable for the arrears of the hire. Also, that the piano should remain property of the owner, but if the hirer had paid punctual monthly installments, the piano should become his property. The hirer, after having paid a few installments, pledged the piano to a pawnbroker. It was held that the hirer was under no obligation to buy, but had an option to either return the piano or become its owner by payment in full. And therefore, he had not bought it, and the owner could therefore recover it from the pawnbroker. So, hire purchase differs from credit sales agreement and conditional sales in the following ways. It is important to distinguish the hire purchase from credit sales agreement and conditional sales. Remember, we have said that the hire purchase contract requires that the buyer pays a deposit. And later pay equal monthly installment until he clear the hire purchase price of the item. And that is the time the ownership passes from the seller to the buyer. What about the credit sales? Credit sales, you buy today, you are given a credit period. Maybe you are given a credit period of 7 days, but immediately you buy, even if you buy on credit, the ownership passes to you immediately. Even if you have not cleared the price. So you pay, you are given the credit period to pay, but the ownership passes to you immediately. So while all the three involve payment via installment, they however differ from hire purchase in the following sense. Credit sales agreement. So the credit sales agreement, this makes it the customer's legal obligations to buy in that it is a contract of sale. The property in the goods passes to the buyer as soon as the first installment is made. Then you have the conditional sale. So this is a contract. This contract makes it the buyer's obligations to buy, but property in the goods passes to the buyer only if the conditions only if the conditions that form the subject matter of the sales have been fulfilled. So what are the provisions relating the hire purchase provisions written to hire purchase contract, or the provisions relating to hire purchase transactions? So before the hire purchase agreement is entered into, the owner is bound to notify the prospective hirer the cash price of the goods. However, the owner is not bound to do so if A. the hirer has selected the goods or similar goods by reference to a catalog stating the cash price. And the other note is that the hirer selects the goods or similar goods from the selection which stated the cash price. So in simple terms, what we are saying is that whenever goods are going to be sold on hire purchase, the seller must quote two prices. The seller must quote the cash price of the item and also quote the hire purchase price of an item. If you opt to buy that item in cash, then the cash price is given. If you opt to buy on hire purchase basis, then the hire purchase price is already provided. So that is the provisions of the law, that the seller must indicate the cash price of the item and the hire purchase of the item. Number 2, the hire purchase agreement must be written. So for a contract of hire purchase to be enforceable and also to be legal, it must be in writing. It must be supported by a written document for it to be a legal contract. So what are the contents of the agreement? So the first content is that there must be a description of the party. So remember, we have two parties. The first party is the seller and the second party is the buyer. So we have the description of the parties. The buyer and the seller their name must be given. Then description of the goods. So what are you buying? Are you buying a TV set? Is it a laptop? Is it a milking machine? Is it a generator? Is it a water pump? Is it a motorbike? So the item that is being transacted must be indicated. That is description of the goods. Then another one, the cash and the hire purchase price. The cash and the hire purchase price are also required to be there in the document of the contract, or the contract document. So the amount, that is the number of installments that you are required to pay. If you are to clear that amount in 5 equal installments, in 6 equal installments, or in 12, so whichever the number of installments, it must be given. It must be indicated in that agreement. So amount and when payable. So amount and when payable, this should also. So each installment, how much are you supposed to pay? If you are supposed to pay 1,500 shillings every month for the next 12 months, it must be clearly given. So it must be signed by the hirer and by or on behalf of the owner. So there must be a sign or a signature to show that the document is valid. Right of the hirer. So it must also, the content or the agreement must also indicate the right of the hirer. It must indicate the right of the hirer. So registration of the hire purchase agreement. Remember, for a hire purchase agreement to be valid, it must be registered, must be registered with the registrar of hire purchase, the registrar of hire purchase. So section 4 subsection 1 of the Hire Purchase Act in Kenya establishes the registry of the hire purchase, and this is the public office which may be held by the registrar, assistant, or deputy registrar. As per the Act, every hire purchase agreement must be delivered to the registrar for registration within 30 days of its execution. However, the registrar is empowered to, at times, extend the duration. So the registrar may extend the duration from 30 days to any number of days that he wish to extend. But the rule states that the contract of hire purchase should be registered within 30 days after the transaction. So the registrar may refuse to register a hire purchase agreement if, so examiner may ask you, under what circumstances will the registrar of hire purchase refuse to register a hire purchase agreement? So these are the conditions, or the conditions under which the registrar may fail to register a hire purchase agreement. If it is not in English language, so if it is written in any other language other than English language, the registrar will refuse its registration. The commissioner may reject or refuse registration. First of all, we have said that it is if it is not in English language. So the other one is if it is presented after 30 days of its execution, meaning that the agreement is being presented to the registrar for registration when it is read. Remember, he has said that you should register an agreement within 30 days from the date the agreement was signed. Another one, if the stamp duty or registrar fee payable has not been paid. So that's another thing that may make the commissioner or the registrar to refuse registration. So registration of hire purchase serves two purposes. Registration of hire purchase serves two purposes. It protects the party who may purport to buy the goods from the hirer. It also it is a revenue generation mechanism for the state. So when you register your agreement, it is required that you pay the stamp duty. Stamp duty is an income for the government, and therefore we are saying that it is a revenue generation mechanism. So what are the effects of non-registration? So what will happen if you fail to register? In the event that the agreement is not registered, the following will occur. The agreement cannot be enforced by any person against the hirer. Any contract of guarantee in relation to the hire purchase agreement is also unenforceable. The owner cannot enforce the right to repossess the goods from the hirer. Number 4, any security given by the hirer under the hire purchase agreement or by the guarantor under a contract of guarantee is unenforceable. So protection of the hirer. So how is the hirer protected by the law? So the hirer or the hire purchase attempts to protect the hirer for exploitation or from exploitation through the following ways. Number 1, making some contents of the agreement to be void if used. Implied terms of the agreement, repossession of the agreement, repossession of the goods. So contents deemed to be void if inserted in the hire purchase agreement. So contents deemed to be void if inserted in the hire purchase agreement. So remember, void, we say that it means that it is declared null and void, and therefore the contract has been rendered unenforceable. So number one, a provision which allows the owner or his agent to enter into any premises to repossess the goods let under a hire purchase agreement. Number two, a provision whose effect is to relieve the owner from liability for such entry that is stated in number one above. 3. A provision which excludes or limits the hirer right to terminate the agreement. And number 4, a provision which deems persons acting on behalf of the owner in the formation or conclusion of the hire purchase agreement as agents of the hirer. A provision whose effect is to relieve the owner from liability for acts of persons acting on his behalf in relation to the formation or conclusion of the hire purchase agreement. So those are the contents deemed void if inserted in the hire purchase. So they are not supposed to be included for a contract to be enforceable. So implied terms and conditions. Implied terms, conditions and warranties. So the Hire Purchase Act implies both conditions and warranties. Both conditions and warranties in all hire purchase agreement. In all hire purchase agreement. So conditions. Conditions there is a condition that the seller will have the right to sell, or maybe the hirer, the owner, or the seller, in this case, the hire purchase entity, has a right to sell. So an implied condition that the owner will have the right to sell the goods when the property is to pass. Number 2, merchantable quality. So is the item that you are being the item that you are purchasing on hire purchase, is it does it fulfill the merchantable quality? So unless the goods are second hand, the agreement so provides there is an implied condition that they would be of merchantable quality. Number 3, fitness for purpose. So the goods that you are purchasing should fit the purpose for which you are purchasing. So where the hirer expressly or by implication makes known to the owner the purpose or the particular purpose for which the goods are, there is an implied condition that the goods would be reasonably fit for that purpose. Assuming you are purchasing a graph book and you have already included in an agreement, or maybe you have already informed the seller the purpose for which you are purchasing that book. You want maybe to use it for graph work, and then this person sells to you a book which is not corresponding to that purpose, then that one will go against the purpose. It is simply means that it won't fit the purpose for which you are purchasing that book for. So another item is a condition may be implied by any other law. Condition may be implied by any other law. So warranties. So what is a warranty? So there is a quiet possession. Quiet possession, we say that this is a circumstance under which the seller, the moment you purchase that item, you are supposed to be able, you're supposed to be able to enjoy that item, even if you have paid in part, you have not cleared the installments. The seller should not have any restriction on how you use the item. So you should enjoy the item without any restriction, so long as you take care of the item. Assuming it's a TV that you purchase on hire purchase, you're supposed to enjoy that possession without any restriction by the seller. Yeah. So there is an implied warranty that the hirer will have and enjoy quiet possession of the goods. So free from charge or encumbrance. So we say that a charge is a security. A charge is simply, we say that when you take a loan, and that loan you secure that loan using a machine like for example a motorbike. We can say that motorbike is charged simply because it has been used to secure a loan, and therefore the motorbike is not free from charge. So charge is a security. A charge is a security to secure a liability like a loan. So if we say that that item that you are purchasing on hire purchase should be free from charge or encumbrance, it simply means that it is free. It has not covered any liability like loan. So under section 8 subsection 1c of the Act, there is an implied warranty that the goods shall be free from any charge or encumbrance in favor of a third party when property is to pass. And 3, a warranty may be implied by any other law. Warranty may be implied by any other law. So another point is repossession of goods. Repossession of goods. So under section 15, remember repossession, whenever the buyer who buy goods on hire purchase fails to pay installment, he terminates the hire purchase contract. The moment you terminate the hire purchase contract, the seller is allowed by the law to come for the item, to come back for the item, and that is what we mean by repossession. Repossession is when the seller comes for the item that you purchase on hire purchase due to terminations of the terms of the agreement. So under section 15 subsection 1 of the Act, if at any time 2/3 of the hire purchase price has been paid by the hirer or any other persons on his behalf, the owner cannot repossess the goods otherwise than by court action. This provisions was intended to protect the hirer from the common law practice of snatchback. Remember, we say that the common law was very harsh. It was very harsh, and therefore, in such a case, under provision of common law, even if you have paid 99% of installment and you default to pay a 1%, that one will make the seller to come back for the item, regardless of the amount that you have paid. That is under the common law. That is what it means by snatchback. So under which the owner will repossess the goods at any time. If the owner possesses the goods in contradiction to the act, then the agreement terminates. The hirer is discharged from all liabilities under the agreement. The hirer is entitled to recover all sums paid under the agreement or the contract of guarantee. The guarantor is entitled to recover any sum paid under the contract of guarantee or under the security given. The section does not adequately protect the hirer in that the hirer must pay too much to be protected by the section. Number 2, property in goods does not pass to the hirer even after paying 2/3 of the higher purchase price. The court may still order the repossession of the goods. The court may still order the repossession of the goods. So duties and obligations under the hire purchase agreement. The duties under the hire purchase agreement. So duties of the owner. Duty of the owner, that is the seller. Number 1, duty to notify the hirer of the cash price. Remember, I said that for a hire purchase contract to be enforceable, the seller must quote the cash price and the hire purchase price of an item. So both the hire purchase price and the cash price. Number 2, the owner must send a copy of the hire purchase agreement to the hirer within 21 days of execution. Number 3, the duty to put the hirer in possession of the goods let under a hire purchase. So duty to separate the hirer in the event of defective. So duty to compensate the hirer in the event of defective goods. So the owner is bound to disclose to the hirer any defects in the goods or in his title. So those are the duties of the owner. What about the duties of the hirer? So number 1, reasonable care. So when you buy a TV set on hire purchase, we said when we were starting, we said that what you get is the possession of the item, but the title or ownership remain with the seller, and therefore you need to take care of that TV because it belongs to the seller. Anytime in the event of default, the seller is entitled to repossess it. So you have a duty of care. So it is the duty of the hirer to exercise reasonable care in relation to the goods let under the hire purchase agreement. However, the hirer is not liable for ordinary wear and tear. Number 2, take delivery. So the moment goods are delivered to you, there is a duty that the hirer must take the delivery. So the hirer is bound to take delivery of the goods under the hire purchase agreement. Number 3, pay installments. So whenever you have decided to buy items on hire purchase, you pay installments as they fall due. Number 4, continue hiring. You continue paying those installments. It is the duty of the hirer to continue hiring the goods for the agreed duration, and this obligation does not deny the hirer the right to terminate the agreement. Number 5, notice of change of location of goods. It is the duty of the hirer to inform the owner any change in the location of the goods. Since we are saying that when you buy on hire purchase, the item, the ownership or the title remain with the seller, and therefore the seller needs to know where the item is at any particular time. If you transfer maybe from one town to another, it's good that you inform the seller. On your new place. So a right of the hirer. So what are the rights of the hirer? rights of the hirer. He is entitled to be notified of the cash price of the goods. Cash price of the goods. He is entitled to a copy of the hire purchase agreement within 21 days of execution of the agreement. He is entitled to indemnity for any loss or liability arising by reason of any defect in the goods or of title. And number 4, he is entitled to quiet possession of the goods let under the hire purchase agreement. And number 5, he is entitled to damages for any breach of contract by the owner. He has the right to terminate the hire purchase agreement at any time before the final installment falls due. Remember, we said the hire purchase contract gives the buyer an option to purchase, and therefore, if you choose to exercise the option, then you purchase, you pay up to the final installment. But if you feel to discontinue repayment of installments, the owner will just come for his own item. So you don't have an obligation to keep paying. You pay because you want to exercise that option. So termination of the hire purchase contract. So to terminate is to render the contract to an end. So to terminate is where the contract comes to an end and both parties are relieved or are discharged. So the hirer, before the final installment, may terminate the agreement by giving a written notice of termination. So termination, so the contract will be cancelled or will be rendered to an end. So returning the goods. The moment you return the goods, it means that you have decided to terminate the contract. So once this is done, the depreciation clause or the minimum payment comes into play, in which case the hirer has to pay all installment due up to the termination day. The amount by which one half of the hirer purchase price exceed the total amount paid or such lesser amount as agreement may provide. Note, if the hirer has not taken reasonable care of the goods, he is liable in damages. The hirer must at his own expense return the goods to the premises from which delivery was taken. However, if the goods are returned elsewhere by reason of owner's change of location, any additional expenses are recoverable from the owner. So that marks the end of the contract of a hire purchase. Remember, in this topic, the examiner may ask you to give the duties of the hirer and the duties of the owner, rights of the owner and the rights of the hirer, that is the buyer. You may also be asked the circumstance under which or how a contract of the hire purchase is terminated. Also, it's good that you go through the repossession of goods. So how the owner can depossess the goods. So conditions and the warranty. You may also be told to explain conditions and the warranty. Another thing that the examiner is likely to ask is the content of the hire purchase agreement. So it's good you know the contents, you read and revise the contents of the hire purchase contract. Another thing is how the hire purchase is protected. That is, the hire purchase customer is protected. So registration of the hire purchase agreement and the effect of non-registration, it's also important to go through it. Another thing that we need to know is the content of the agreement. The content of the agreement is very important. So what you need to insert in the contract, or the document that is to be signed by the seller and the buyer. So that is all about the contract of hire purchase. Contract of hire purchase. And that is the end of our lesson.